Good morning. The 36th District Court in the state of Michigan is now in session with the Honorable Judge Donald Coleman presiding. While court is in session, there will be no talking, sleeping, chewing of gum, or reading any materials, and no driving. Thank you.
Thank you, officer. This is case number 22, 190-992. This is Michigan Institute of Musculoskeletal versus City of Detroit. The matter is before the court, set on for a pretrial conference. A discovery order was previously issued regarding this matter. Your appearance for Michigan Institute.
Good morning, Your Honor. Mark Gozer for the plaintiff, P number 79070.
Thank you, counsel. Good morning to you, sir. For the defendant, City of Detroit, your appearance at this time, counsel.
Good morning, Your Honor. Alfred Ashew, P 82536, on behalf of defendant, City of Detroit.
Thank you, Mr. Ashew. Good morning to you as well, sir. All right, so I know that this is a claim that sounds in the neighborhood of $17,500. I know you've had some opportunity to advance a discovery. Update me, if you will, regarding where we are in this matter.
I gave Mr. Ashew a demand. I think I'm waiting to hear back. I imagine he's waiting to hear from his client in regards to that demand that we provided.
Sure, Your Honor. We just need a little bit more time. So if the court would be obliged to just set it on track for a trial date, and we'll continue to resolve it or to continue to work toward a resolution in the meantime.
All right, very well. What I'd like to do in this matter is take another look at it in 30 days and to see where the parties are now, if there's been any progress in terms of narrowing whether or not it can be resolved. And then I would set a trial date at that point. Does 30 days seem to be enough time to kind of get a better gauge on where the exchange is?
I believe so, Your Honor.
Yeah, that should be fine.
Just going to set it for a review, regarding a pending demand. And we'll just see where things are at that point. It's a short leash, and then it needs to go. I need to set it up formally for trial. Do it at that time. So the next action date in this matter is going to be the let's do it the 13th of March, 3/13/23, and that's going to be at 9:30 a.m.
Okay.
All right, gentlemen. Thank you for the update, and I will see you in about a month or so.
And Your Honor, if I may, I just want to add one thing. I'm not sure if the court is aware, but there is a broken link on the 36th District Court website. So when you go to Zoom and you click Judge Donald Coleman, it takes you to another room. So to get to this room, you have to click 336, but I'm not sure if that information is readily or widely known. So that may affect some appearances here. Just a heads up.
Yeah, I appreciate that. And the problem here is that my Zoom number is 336. It was that originally, and then it was supposed to be 534. And it's a little bit crazy. So all of the notices that you'll get from me going forward will have the 336 on it. What happened is my courtroom was 336, and that was my Zoom number. So my courtroom was changed to 534. I presume that the 534 Zoom number will go there as well. But I got the courtroom but not the Zoom number, so I'm still at 336. And some of my notices went out with that, with the 534. And so yeah, it's kind of messed up. But it should clear up because I'm at 336 until further notice.
All right.
Sure.
Thank you, Your Honor.
Thank you, Your Honor.
Good. Thank you, Counsel.
Your Honor.
Yes.
I was just told I'm contracted. I was asked to just appear to advise that there's an adjournment. The court wanted us to appear today just to advise of that on the case that I'm on, Macomb Community College.
I don't, okay, I got it. All right, this is case number 14-116-314. This is Macomb Community College versus last name is Fortner, Foutner. Matter is properly set regarding a subpoena in this matter. Counsel, your appearance regarding this.
Certainly, Your Honor. Good morning. Sheila Siegel appearing on behalf of the plaintiff, Macomb Community College, for attorney of record Kenneth Cohn.
Thank you. Your P number, if you will.
Sure, 46184.
All right, thank you. Thank you, Madam Counsel. Is there anyone on the other side of this? If you're on the Zoom, say something. Any other person interested in this matter? Go ahead, Counsel. You had some.
Yes, there wouldn't be, Your Honor. The defendant Foutner would not appear today. We had called the court about an adjournment, but they did want us to put this on the record. So I am here today. So if we could just take care of it for today.
Yeah, I see that there were communications made with my clerk requesting that the matter be adjourned. And I see there is a offer of a fresh subpoena in this regard, so that we could set a new date on it. I suppose that is what the effort is here. All right, so how much time is needed regarding an adjournment of this matter?
Your Honor, I believe it was 3 to 4 weeks, but I didn't take care of that end of it. I was just told to appear today that the matter has been adjourned, in keeping with the court's request to make a record of what transpired. Effectively, it transpired as far as requesting an adjournment, that it was not going today.
All right, yes. All right, so
I believe a date may have been secured, if I recall correctly. I'm
looking through notes here. Actually, what was requested is 8 more weeks to service it.
okay, then 8 more weeks. Yeah, that's a lot more than 2 or 3. So.
Well, not only a lot more than 2 or 3, that's just a lot. I mean, are you going to serve the subpoena or not? So we'll go ahead and set another date. Let's go ahead and put this out for 20th of. I'm going to go ahead and put it for the 20th of March 20th. Will be the adjourned date.
That's a Monday, Your Honor.
Yes, ma'am.
Okay. And the same time, 9:30?
9:30 a.m. Thank you, Madam.
Okay, very good. Thank you. Have a good day, Your Honor.
This is case number 22-194368. This is Humans and Company versus Motown Historical Museum. The matter is before the court settled for a pretrial conference. Your appearance for Human and Company, for Motown. All right, so I have Mr. Just one moment. We're going to pass on that matter, Madam Reporter. We'll come back to it. All right. This is case number 22-196025. This is Tansy Smith versus First Third LLC. The matter is before the court, set on today's docket for a pretrial. I did issue a scheduling order that allowed discovery through today's date. Your appearance for plaintiff in this matter, please.
Good morning, Your Honor. Bayan Jaber appearing on behalf of Plaintiff Tansy Smith, and my colleague, the partner assigned to the case, Carrie McGee, will be joining us in just a moment.
All right, your P number, if you will, for the record, Madam Counsel.
Of course, P85451.
All right, thank you. And for the defendant in this matter, your appearance, please.
Good morning, Your Honor. Anthony Gonzalez, P85154, appearing on behalf of First Third LLC.
All right, thank you, Mr. Gonzalez. Good morning to you as well, sir. And Madam Counsel, I know you said someone else was joining. Can you go ahead and give me an update on where things are at this point?
Sure, Your Honor. So the parties have entered a stipulated order to adjourn discovery dates 45 days. I believe that was entered by defense counsel yesterday or the day before. And we're currently working on exchanging discovery in the matter. And the plaintiffs have filed a motion to amend the complaint as well. And that was filed, I believe, on yesterday morning.
All right, so Mr. Gonzalez, there's an amended complaint that's been filed regarding this matter?
That's correct, Your Honor. So with regard to the stipulated order, that was submitted to the court via U.S. mail yesterday, asking this court to extend discovery 45 days. And as counsel indicated, the plaintiffs filed a motion for leave to amend the complaint under the court rules.
So with regard to the request to extend the scheduling order, so has there been some discovery activities that have been taking place already?
Yes, Your Honor. There has been written discovery exchange from the plaintiff to the defendant. We have answered the initial request for admission, and we plan to submit our answers to the interrogatories and request to produce in the coming days.
All right, well, it looks like the parties have been making some progress towards narrowing the issues, which is one of the primary purposes of the discovery process. I don't like for time to just pass by and no action occur, but it seems the parties have been moving along in a responsible way. Under that scenario, I'll go ahead and extend, grant the requested extension with regard to the discovery order in this matter. And so I'm going to go ahead, just one moment. So I'm going to go ahead and set it on for the 23rd of March. That will give you the rest of this month and also most of March. Now, if you think that I need to go ahead and push it into the first week of April, I could technically do that. So go ahead and tell me where you are now. I know that you said 45 days. You're getting some stuff done. Is more time better right now, or if I put it in that week of the March 23rd?
I believe the parties are, at least plaintiff is comfortable with March 23rd. And that's the date that the parties have stipulated to.
All right. Oh, is that the date you stipulated to? I haven't seen the stipulation. Oh. Whatever you sent in, it hasn't populated to the file yet. So if I picked your magic date, yeah, that would be interesting. You'd be looking at me like, why is he asking that? We already sent that in. I haven't received that. Is that the date that you were requesting?
Your Honor, if I may, the date identified in the order was March 24th, but still very close to what the court indicated.
All right. So I haven't received, it hasn't populated yet. So we'll go ahead.
Understood.
And set for March 23rd. And of course, the general rule here with me is that, if you're making progress, then getting additional time to kind of work through stuff is not going to be much of a problem. As long as you're making progress. The idea that there's a requested amended complaint, so on and so forth, makes the cases moving. So when lawyers say they need a little bit, some additional time, I don't have a problem with that. I know how that works. So the 23rd of March at 9:30 a.m. will be the next action date. The court will extend the discovery order as well as the scheduling order through that date. And so we'll see you on the 23rd of March at 9.
Your Honor, if I may, Forgive me, Your Honor. Will the court at that time hear or entertain the motion filed by the plaintiff to amend the complaint?
And that's the other thing is, of course, that has not populated to the court's file. Let me just take a look. But let's address that right now, in as much as we are here. I take it that there is not a stipulation to amend the complaint, elsewise it would not be in motion. But of course, the court rules tell us that we allow amendments as justice so requires. What are you? Why are you amending at this point? What's the heartbeat of your requested amendment, sir?
Your Honor, good morning, Your Honor. This is Carrie McGee. I haven't met you yet. Nice to meet you. Sorry I got on a bit late. You were very prompt here, and I'm just a bit late. I apologize for that. So it's nice to meet you. That was a motion that we filed to amend. We did provide a copy of it to the defendant and had a meet and confer in an effort to try to see if we could reach an agreement. So there was an effort to do that, but we weren't able to reach an agreement, and that's why we filed the motion. This was originally filed in pro se, and the plaintiff who filed it just didn't more specifically assert the causes of action that really apply to the facts. And so we're just more specifically stating those causes of action. We also have added the property manager as a party defendant who is very much involved in this case in relation to failure to repair the property and remediate a mold issue. And we've also requested to add party defendant, Mr. Collins, who is the owner of First Third, the entity that owns the property. And so that is the subject matter of the motion. No statute of limitations issues apply here. We're well within that. And as the court has stated, leave is freely given, even at the time of trial, to conform with the proofs. And so under MCR 2.118, we feel that an amendment is appropriate.
I noticed that on the filing of the initial complaint, the case $5,000 with the requested amendment. Is there a plea for damages in excess of the original damage?
Yeah, up to $25,000.
So instead of capping it where it was initially, you're leaving it open under the proposed amendment, damages within the jurisdiction of this court, correct?
That's correct.
So counsel, Mr. Gonzalez, so what's the problem?
Well, Your Honor, we have a written response that we intend to file with the court, but I'm happy to address those arguments now. As the court indicated, leave is freely granted under MCR 2.118 as justice so requires. But Your Honor, this lawsuit is being filed against a limited liability company, First Third LLC, and we believe the plaintiff has not set forth sufficient factual or legal allegations to pierce the LLC veil in this case. The plaintiff is attempting to name Mr. Carl Collins III, who is the registered agent and sole member of First Third LLC, along with Thomas Wilson, the property manager. The plaintiff entered into this lease agreement with the LLC, not with Mr. Collins and not with Mr. Wilson. And we believe, Your Honor, that the request to amend the complaint to name these two individuals is arguably futile for those reasons regarding the LLC veil. And we honestly believe, Your Honor, that amending the complaint to name Mr. Collins is really done more so to embarrass him and not because he has any connection with the allegations as set forth by the plaintiff. As to the underlying merits of the complaint, Your Honor, the plaintiff's motion seems to indicate that there is no significant change between the factual allegations the plaintiff identified in pro per and the ones identified in this first amended one. So while leave is really granted as justice requires, Your Honor, we believe that because there are no sufficient facts to pierce the LLC veil, and because it would be futile in this case, that the court should deny the request to amend the complaint to name Carl Collins and Thomas Wilson at this time.
And Madam Counsel?
Sure. Well, I mean, first of all, with regard to the claims, we've asserted a breach of contract claim, a negligence claim, and a premise liability claim, claims that provide certain damage relief. And I think it's important going into trial that it's clear to the court what the claims are and what the damage availability is. And so that's necessary for framing the issues at trial, and the interest of the plaintiff to rescind the contract that was entered into for a property that had never been certified as a property that was ready to be rented in violation of a Southfield ordinance. In terms of Mr. Wilson, he's the property manager. He's responsible for managing the property. He's a person that certainly has liability in this case. He was responsible for the repairs of the property. He was an individual that Ms. Smith was dealing with on a daily basis with regard to property problems. And so he's a proper party to this case. And in terms of Mr. Collins, also the communications between the plaintiff and Mr. Wilson demonstrate that Mr. Collins was making the decisions on efforts by Ms. Smith to be compensated for property damage that existed in multiple text messages. Mr. Wilson said that he couldn't do anything because Mr. Collins was the individual who had made that decision. So I think in terms of Mr. Collins, we perhaps will need to have some more information from the defendant on that issue as to whether he's a proper addition and whether the first third is sufficient. However, with Mr. Wilson, clearly he is a proper party as the property manager in this particular case.
All right, I think that you, unless I got something wrong, you were talking about, first you were talking about Mr. Wilson, then you were talking about Mr. Collins, and then it seemed that you kind of inverted a little bit. You were talking about Mr. Wilson when you should have been talking about Mr. Collins. Which one are you saying that you need a little more information as to whether or not they might actually connect to this matter, or whether
Mr. Collins,
Mr. Collins,
who's the owner of First Third.
Got it. All right. Yeah. Here is the challenge as it seems to me. I don't have the written documents, but again, these things come up. My inclination here is to allow the amendments as justice so requires, given the fact that what happens is that the parties get to hash this out in the context of litigation. So the pleading is mostly notice pleading, indicating what the plaintiff believes they can advance. And then it gives the opportunity for the defense, of course, to challenge that. And so what Mr. Gonzalez seeks to do, and it's not unreasonable, he seeks to challenge that prior to the amended complaint. None of those challenges are forfeited should the court allow the amendment. And I think that that's the nature of the rule, where the court allows amendments where justice so requires. Where there is no prejudice that occurs, then you typically, the court would typically allow for the amendment because the defendant would not be prejudiced in that they would retain all of their rights to move and challenge things that are set forth, various claims and parties that are set forth in the amended complaint. Under that scenario, I'm going to do something that I don't typically do it this way. I think I have enough information to rule on the motion, and I will grant the motion allowing the amendment based upon the statements that I've heard that justice was so required, and that the attacks on the adding of various individuals as well as the adding of claims is not prejudiced by the court allowing the amended complaint, and the defendant would have the opportunity to raise the challenges that would be appropriate and that would be normally allowed therein. So I will allow the amendment of the complaint. The amended complaint must, in fact, be filed and served with the court and on defendant on or before the 17th of February, 2022, 2023. So.
Thank you, Judge. Do you need us to prepare an order, or will there just be an entry made on the court docket?
You should prepare an order on that. I would normally do it, but I'm doing a lot of things right now. Let me give you
Sure.
an email address where you can email that order. That is Carmen, first name Carmen, CARMEN, dot, last name is Banks, BANKS, at 36districtcourt.org, 36th.
And Judge, can I get counsel's name and P number again, please?
Well, you have Mr. Gonzalez, correct?
Yeah, just the lady.
Sure.
Third one.
Let's start with, is it, Jabbar? How's your last name?
No, I have hers. It's the other lady, the
Sure.
one that was last.
Sure.
This David was the one I was having a struggle hearing.
Yeah.
But, all right, let's go. Counselor, if you will indicate your appearance once again, please.
Sure, Your Honor. Carrie McGee, my P number is 42318.
Okay, thank you.
Thank you.
Madam Counsel, I'm sorry, Madam Clerk, Madam Court Reporter.
Yes.
All right, Madam Counsel, if you will include in that order, notice of hearing date of March 23rd at 9:30 a.m. as the next action date regarding this matter, and that the scheduling order is continued through that day.
Okay, so you want us to include that in the order?
If you will, go ahead and
Okay.
include that in the order.
Okay, and just include the new status conference date for March 23rd at 9:30 with the remaining dates the same as in the original scheduling order in terms of to be determined.
Exactly right. Exactly
Okay.
right.
And just one other, yeah, go ahead, I'm sorry.
Extends discovery. That's a critical part of it.
Right, and the discovery. Yeah.
Just indicate that you are extended, that the scheduling order is extended through March 23rd.
And just again, for clarification, just make sure we have the email right. It's Carmen.banks at 36th District Court. That's all spelled out, right? .org, 36th District or 36th.
36th. Only one
Yeah.
dot between Carmen and Banks. Carmen.
Dot.
Banks. Only one
Right.
dot.
And District Court is spelled out.
District Court is spelled out. 36th districtcourt.org.
Got it.
All right. Thank you. Thank you all. And we'll
Thank you,
see you at-
Judge.
Thank you, Your Honor.
Thank you, Your Honor.
Thanks. Bye-bye.
All right, on Humans and Company versus Motown Historical Museum, suffix 4368. I call up that matter. Any parties on that matter? Your appearance, please. We'll pass on that one, Madam Clerk. This is case number 101, strike that 10-103-293. This is Calvary SPV 1 LLC versus Elizabeth Litzy. The matters before the court on the following objections to a writ of garnishment with regard to the Michigan Department of Treasury. The record should reflect that a judgment was entered in this matter in 2010. That judgment was renewed subsequent to that time. There appears to be a balance that remains on the judgment as it was renewed in 2020 for $2,452.86. Your appearance for Calvary, please. All right, do I have Elizabeth Litzy on the Zoom? Elizabeth Litzy, our matter is set today, actually was set at 9 a.m. I had it off at 9:30. Ms. Litzy, are you here? It appearing that the defendant has not appeared And looking at the objection, it says the funds are exempt. And there's no further information. The court would have to make the finding then at this point that that the objections are invalid, and any funds withheld will be released to the plaintiff under the garnishment. So forth. The court now calls case number 16-11-4058. This is Cash LLC versus Omar Woods. The matters before the court regarding a garnishment relative to the third party withholding unit of the state of Michigan. The record should reflect that there is a judgment that was entered in this matter in 2017. $1,483.58 is the amount on entry. There appears to be an outstanding balance in the judgment, and the objection, the garnishment has been issued accordingly. For Cash LLC.
Good morning, Your Honor. Michael Beach, BEACH, P45459.
Thank you, Mr. Beach. Good morning to you, sir. Do I have Omar Woods on the Zoom? Omar Woods, or anybody representing Mr. Woods? The matter's properly, well, actually, yeah, the matter's properly set on for 10 o'clock a.m. Again, looking for Mr. Woods. All right. Just one moment. It looks like Mr. Woods have not appeared regarding this matter. The court notes the objection indicates that the writ was not properly issued or is otherwise invalid merchandise was stolen. I never received it. Those things would sound like an attack on the underlying judgment in this matter, and that certainly would not be allowed in such a hearing. Counsel, have you spoken with Mr. Omar Woods regarding this matter at all, sir?
Your Honor, no, we have had no calls or discussion with them.
Thank you, counsel. It appears that the objections would then be invalid based upon the presentation of the document, particularly where the defendant has failed to appear for this hearing. Accordingly, the court will find again that the objection is invalid and will allow the release of funds to the plaintiff. I've signed the order consistent therewith. Thank you.
Thank you, Your Honor. You have a good day.
The court now calls case number 20-141052. This is Garden View Homes 1 versus Latina Randall. The matter is before the court on the following of objections to a writ of garnishment issued as it relates to the Black Jews Services, JRW Services Incorporated. The court, looking at the file, it appears that a judgment was entered in this matter by default on the 17th of April 2020 for $3,979.45. That judgment appears to be outstanding and provides the basis upon which the writ of garnishment was issued. Looking at the objection, it says it was not aware of the garnishment. All right, your appearance for Garden View, please.
Good morning, Your Honor. Gary Feynman appearing on behalf of Garden View Homes.
All right, thank you.
P41-655.
All right, thank you, sir. Good morning to you. I'm looking now for Miss Latina Randall. If you're on the Zoom, say something at this time, ma'am.
Good morning, Your Honor. I'm here.
All right, good morning to you, ma'am. I noted your objections. You said that you weren't aware of the garnishment. That really doesn't provide an objection to it. Oftentimes, a garnishment is issued without the party being aware of the same. So, is this your workplace where you're being garnished, ma'am?
Yes, it is.
All right. So, anything else you want to tell me about this, ma'am?
Yes, the garnishment, if I would have known, I would have reached out and made a payment arrangement. the thing is with the garnishment of my wages, my hours vary. So, and plus I'm a single mother with 2 children. So I just want to make sure I'm able to pay my other bills that I have. So I'm willing to make a agreement to pay something monthly, but I'm seeing that my wages are already started to be garnished.
All right, ma'am. So do you get paid weekly, bi-weekly, or how do you get paid, ma'am?
I get paid weekly.
All right. So how much is being garnished weekly? I know it's 25%, but roughly.
When I looked at my recent paycheck, it was $152
All right.
that was took out.
Got it. So basically, that, on average, you'd end up with 150 a week, about, so that would bring you to about 600.
Like I said, my hours vary, so it doesn't stay the same. So the
Right.
my last pay after the garnishment was like $400 and something.
The garnishment was $400+, you said?
No, the garnishment was $152. I was left with $400 and something.
Right, right. I want to keep this focused, guy. I don't want to address what you left with. I want to address what is being taken by way of garnishment. So
$152, Your Honor.
gotta listen to me. Okay? We're trying to go slow with it. So on average, it would seem that your garnishment would be somewhere in the neighborhood of 150, maybe a little bit more than that. And then that would happen 4 times a month. So that would put you at $600 a month. That would be taken from. Is that correct, ma'am?
Correct.
And as you indicated, it could be more at times based upon the number of hours that you may work. Correct?
Correct.
All right. So you haven't filed a motion for partial payments, but let me ask you, how much are you asking the court to allow you to pay this on a monthly basis? And what type of payment arrangement would you anticipate?
Can the court allow me to pay the $152 monthly?
Counsel, what are your thoughts in that regard, sir?
Well, I don't have any authority. I'd have to make a phone call.
And so, ma'am, you said you had 2 children that you're providing for, and how much is your rent? Or
I have property taxes and I have a mortgage loan of $900 monthly.
okay, gotcha. You have a car, ma'am? Do you have a vehicle?
Yes, I do.
Right, and how much is your vehicle costing you a month, ma'am?
I own it right out, so I pay the car insurance, which is roughly $200 and something a month.
All right, gotcha. All right, do you receive some support for the minor children, ma'am?
No, I do not.
There's not an order for child support, anything along those lines?
No.
All right. So any other source of income that you have?
No, I do not.
All right. My inclination is to grant you the opportunity to pay the $152 a month, and as long as you make that payment, then your wages would not be garnished, and so the garnishment would be suspended. If you miss the payment, then the garnishment would be reinstated. You understand that, ma'am?
Okay.
So I'm going to, on your petition, based upon your recitation of the resources that you have, I will grant you the right to pay on an installment order. Any funds that are already taken, those funds will be withheld, will be retained. I will find that there is not a valid objection to the garnishment. Any funds released, withheld will be turned over to the plaintiff in this matter, and then I'll suspend the garnishment on my order for you to make the monthly payments. I'm going to commence your monthly payment regarding this matter, ma'am, on the 3rd of March. What's going to happen is that you're likely to be garnished one more time before that date, but then March the 3rd will be your first date to make payment under the order. you'll get a copy of the order from the court. When you get that order, you want to take that to your payroll department. And they will use that as a basis to stop the garnishment. Understand? All right, ma'am, did you understand what I said?
Yes, I understand, Your Honor. Thank you.
All right, now, so you get paid tomorrow, is that correct?
Correct, Your Honor.
All right, so, ma'am, why don't you do this? Why don't you send to the court, or why don't you chat your email address so that we can email you a copy of this order, and then you can take it to your payroll. So, because otherwise what will happen is you'll get garnished tomorrow and then you get garnished again next week. So, but if you.
Okay, Your Honor.
Tell me your email address and we'll email this right away. We can't stop tomorrow, but we can stop next week, and then you will start with making the payment voluntarily on the 3rd of March. You understand?
Okay, Your Honor. So you said for me to give you my email address?
Yeah, put it in, you know how to chat it, look on your device, it should give you a chat option to chat it to.
I'm sorry, Your Honor, I wasn't allowed to go into the Zoom because I couldn't hear, so I just called the number. So that's how I'm on the Zoom. I'm not actually in the meeting because I couldn't hear anything.
Okay, so, but on your device, you still should be able to chat something. Well, all right, ma'am, how do we do this now? Because we're online. I'm trying to get the information so that we can send that out.
I don't know if I could try to log into the Zoom now while I'm on the call and see if I can add it into the chat.
All right, here's what, so I'm done with your case. You know what my ruling is. I'll try to log back in and then chat me your email address, okay?
Okay, thank you so much, Your Honor.
Thank you, counsel.
Your Honor, will the court also mail the order to the parties?
Absolutely.
Thank you, Your Honor.
Thank you, sir.
Okay, thank you.
Thank you.
Nope. We don't have them. All right. You won't.
All right, the court now calls case number 20-155-170. This is Jefferson Capital System versus Gregory Thomas. The matter is before the court on the following objections to a writ of garnishment. The court also has received the motion to set aside the default in this matter. All right, your appearance with Jefferson Capital System, please.
Good morning, Your Honor. Dawn Blair on behalf of the plaintiff, P62601.
All right, thank you, Ms. Blair. Your sound is kind of clouded, but I was able to hear you okay there. All right, and now looking for Mr. Gregory Thomas. Gregory Thomas, if you're on the Zoom, please say something at this time. Gregory Thomas. All right, so the matter is set on for 10 o'clock a.m. It's now 10:20. This is regarding the Michigan State Department of Treasury garnishment. Also, this involves the entry of a judgment by default on the 6th of November of 2020. There looks like there have been other garnishments regarding this matter. I looked also at the motion to set aside default, and I don't see anything of any substance in this regard. There was a box check, 21 days have passed, the default was entered. I was not personally served. Then I see that looks like it's scratched out. I'm not sure. It says the court lacks jurisdiction because I was not served. It's item 2, and then I have good cause for failure to appear. For failure to appear answer. I don't see anything on his face that would give rise to setting the default aside. Madam Counsel, anything at this time?
Are you able to hear me okay, Your Honor? I know you said my sound was not good.
It's still a little cloudy, but I'm able to hear you pretty well. Go ahead.
Okay. I would just acknowledge that we did receive a copy of his objection to garnishment. We would request that it be deemed invalid as he is attacking the underlying judgment. Additionally, the plaintiff did not receive a copy of his motion to set aside the default judgment, so you don't have a response from us. But on the record, I would state the same thing, that I am showing that he was personally served with the summons and complaint, did not timely respond, default judgment was entered. And as you've stated, there were other garnishments filed and served to him in the past, to which he has not objected to or responded to. So plaintiff would request that his motion to set aside the default judgment be denied also.
All right, one more time, Gregory Thomas. Mr. Gregory Thomas, if you're anywhere on this Zoom, say something at this time. All right, defendant has not appeared with regard to his objection to writ of garnishment. On the face of the same, it does not appear that there is a valid objection that is stated. So the court will find that the objections are invalid. The garnishment, the garnished funds will be immediately released to the plaintiff. The court will further find that no sustainable objections have been raised with regard to the motion to set aside the default judgment. Defendants failed to appear on that matter as well. The motion to set aside the default will be denied for the reasons set forth on this record. So ordered regarding both matters. All right, counsel, we'll get copies out right away.
Wonderful. Thank you, Your Honor. Have a great day.
All right, likewise to you. The court now calls case number 21-160-918. This is Buford and William Buford and Alice Tillman versus Progressive Marathon Insurance Company. Today is the date and time set for a pretrial conference in this matter. Your appearance at this time for the plaintiff.
Good morning, Your Honor. Doug Harriskevich, P81458, on behalf of the plaintiff, William Buford.
Thank you, counsel. Good morning to you. For Progressive, I believe that's who's still in Allstate. Go ahead, sir.
Good morning, Your Honor. James Flynn for defendant Allstate, P84708.
Okay, thank you, counsel, and good morning to you as well, sir. Well, my register of action on this file has gotten to 6 pages long. Somebody update me and tell me where we are. I know Mr. Buford, as I recall, there were some challenges as to whether or not he could act independently, and then I know that there were challenges with regard to who would be taking over the litigation of this matter, or whether it would be Progressive or Allstate. So I think we've worked those things out. I'll take you from there.
Yeah, Progressive is out. We worked that out. As for Mr. Buford's ability to move forward with litigation, there was a probate matter opened up, and a Destiny Tompkins was recently appointed as his guardian. She actually filed a petition with the court to modify the previous guardianship so she could take over. I've touched base with her over the phone. I've sent her a letter indicating that there's an ongoing lawsuit and that we need her cooperation to contact my office. The one last time I was on the phone with her, she indicated that she has no interest in participating in this litigation. She doesn't think that she has to. At this point, I'm not able to, adequately represent Mr. Buford if I'm going to be obstructed by Ms. Tompkins. So my office will be filing a motion to withdraw.
Yeah, I mean, that's, I remember being there when I was practicing a couple of times, and that's been a long time. All right, so, I will anticipate, your petition to, withdraw. And the court will, I will indicate under these circumstances, my inclination is to grant your order, grant an order allowing you to withdraw from the matter. And Counsel, Mr. Flynn, anything you want to say about this matter?
No, Your Honor, Allstate's been looking for an update on this for a while as well. I anticipated that plaintiff's counsel would likely withdraw. The only thing I would ask is if that motion could be brought, just to keep things moving, is if that motion could be brought within 30 days. And then we would have no objection to it, of course, but then we would ask for just one final status conference. If Mr. Buford or his guardian doesn't show, then the case would be dismissed.
Yeah, I'm trying to find the shortest way to get that done. I think almost on oral motion, I can grant the order allowing withdrawal, and there will be a stipulated order or an order submitted to the court, because Mr. Counsel, not to work on that last name today. Counsel.
I'll help you. It's really, really easy. First part is Harris. Last part is Skevich. Harris Skevich.
Got it. All right, Mr. Harris, it seems that he's made it quite clear on this record of the events that have occurred, and that there is in fact a guardian that has been appointed in this matter and has authority to act regarding this matter, and has indicated specifically that she does not wish to proceed and has no interest in advancing the cause. And with that, it would be incredibly difficult for counsel to proceed in this matter. Could not proceed without the cooperation of the person who has the interest of the plaintiff. And so on that basis, I would grant the right to withdraw in this matter. What I would indicate is that in that order, it would have to give the now plaintiff, the guardian, perhaps 28 days to take action with a notification that the court case would not take within 28 days.
I'm sorry, Your Honor. There was someone slamming a door and I didn't hear after the first 28 days to take action with 28 days.
Or the court would dismiss the matter.
Okay. And when you say take action, do you want to schedule a court date for them to appear for, or just in general have to contact the court?
Yeah, your thoughts, I think, Mr. Flynn. I think Mr. Flynn indicated that, maybe the court set a date for them to actually show up if they wanted to show up. So I would put in the order, and we'll go ahead and give it a date and set it. Let's say that set it for hearing on the 16th. On the 16th of March at 10 o'clock a.m. 3/16, 10 o'clock a.m.
Okay. And you want that submitted as a stipulated order?
You can either do it that way, but whatever you do, even if it's stipulated, put in the introduction to the order that the court heard statements and concluded. Somewhere you want to put in there that I conclude that the factual scenario is such that the plaintiff counsel should have the opportunity to withdraw, and that opposing counsel does not oppose your petition.
Understood, Your Honor. I will have it submitted here today. I don't think we need a stipulated order. I'll just submit the order that granting oral motion.
And what you'll do is you go ahead and email. You got the email address that you can send this to. Let me give you that. The first name is Carmen, C-A-R-M-E-N, and there's a dot, Carmen dot, last name Banks, B-A-N-K-S, at 36 District Court.
Okay. I'll have that submitted. today.
Putting it, the hearing date is 3/16/23. That's gonna be a Zoom hearing.
She just walked out.
And the Zoom number that you wanna put in there is
I'll tell you.
360-336-0000.
Okay, I'll be sure to include that.
Thank you, sir.
Thank you, Your Honor. Have a
Thank
good
you,
day.
Your Honor.
All right, I did not, on the record regarding the suffix 368, I did not receive a response from anybody on the court's call. This was regarding Humans and Company versus Motown Historical Museum. There is before the court a petition for a motion for discovery. Court already granted discovery, so that order is moved. Neither party appeared regarding this matter. Just one more. In fact, my order indicates that this matter was set for trial. And that last note on this matter is from March 30th. That's when the court issued its order for scheduling and set today's date as return date. Given that the defendant, the plaintiff has not appeared, neither parties appeared in case, that case will be dismissed.